Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to talk about magazine bans again today and about a really terrible ruling that's just come out of the First Circuit. Now, I know many of you are sitting there going, listen, I've geeked out on this channel. I've geeked out on a lot of other channels. I really understand this whole concept of the common use test, dangerous and unusual, all that stuff. How on God's green earth could a court still, in the year 2024, post-Bruin, uphold magazine bans? Well, the simple answer is they ignore the law and they get to the result they want to get to. Don't believe me? I'll prove it to you today. So today, let's spend a few minutes and let's talk about bad ruling from the First Circuit upholds magazine bans. Okay, so what is the case that we're talking about today? The case we're talking about today is Ocean State Tactical versus State of Rhode Island. It is a challenge to Rhode Island General Law, Section 11-47, point sections 1 through 3. In other words, this is Rhode Island's high-capacity magazine ban, which was passed a few years ago. In their ban, there was no grandfathering provision like what we endured out here in Washington. No, apparently you either had to turn them in, destroy them, or make them 10 rounds or less. Now, so far, this suit has not really gained any legs. It got before a 3-judge panel of the First Circuit. They have upheld Rhode Island's magazine ban. How have they done so? Well, they've done so by ignoring the law. Now, let us remember that there used to be this old 2-part balancing test where we could actually weigh the level of infringement that the individual is suffering and then compare it to the societal needs that was being theoretically advanced by this legislation. And if the societal needs outweighed the individual intrusion, well, shockingly, the law remained. And that's for many years when everyone was asking, how can these gun laws continue to be found constitutional? Well, that's the way they were doing it. Now, along came Bruin. Bruin said, no. We're going to do away with that altogether. There's no more balancing test. Instead, we're just going to ask ourselves 2 questions. Number 1, does the plain text of the Second Amendment cover the activity which is in question here? And then number 2, if the answer is yes to number 1, is there a historical analog that the government can point to that shows that we as a society have accepted these types of restrictions? If the answer on the second one is no, there isn't, then the law is presumed to be unconstitutional. Now, when we start taking a look at high-capacity magazine bans, when we start taking a look at assault weapon bans, when we start taking a look at almost any form of modern gun control, or as we like to call it here, civilian disarmament, yeah, there is no historical analogs to anything, which means there really is no such thing as innovative or creative gun control anymore, right? Now, in the lower court had actually found that magazines don't even constitute arms at all, so the Second Amendment didn't even cover it. The court here said, no, we believe the Second Amendment does in fact cover these types of magazines, but there's plenty of reasons for which they can be banned. And the sad thing is that the only way the court could get there was actually to ignore the law, to actually resort back to a balancing test. And that's exactly what this 3-judge panel on the First Circuit has done. They have engaged in a balancing test, which the Bruin court specifically told them they should no longer engage in, and I'll show you how. But as plaintiffs concede, today's semi-automatic weapons fitted with LCMs are more accurate and capable of quickly firing more rounds than their historical predecessors, and they are substantially more lethal. And even assuming all of that to be true, so we take it in arguendo, none of that has anything to do with the justification of a modern firearms ban. Now, obviously, the court in the state of Rhode Island ran into a problem. And the problem is that, well, we don't have any historical analog to really justify these types of restrictions. But hey, don't let that get in the way if you're the First Circuit, because you could always rule as follows. The lack of directly on-point tradition does not end our historical inquiry, but it does affect our mode of analysis. The Supreme Court has instructed that cases like this one, implicating unprecedented societal concerns, may require a more nuanced approach to historical analysis. And that nuanced approach is essentially, let's just ignore the edicts of Bruin and let's come up with our own 2-part balancing test. And we start weighing then on what is really the level of infringement to the plaintiffs here in Rhode Island. I mean, are we really thwarting their ability to defend themselves? Don't believe me? This is how the court put it. To gauge how House Bill 6614 might burden the right of armed self-defense, we consider the extent to which LCMs are actually used by civilians in self-defense. The answer supplied by the record in this case is that civilian self-defense rarely, if ever, calls for the rapid and uninterrupted discharge of many shots, much less more than 10. And so the court, serving as a firearms and ballistics expert, believes that, well, you don't really need them because you're just not likely to have to use them, as if that is the actual inquiry. The court went on to state, given the lack of evidence that LCMs are used in self-defense, it reasonably follows that banning them imposes no meaningful burden on the ability of Rhode Island's residents to defend themselves. That is a balancing test in its purest sense. If you go back and you read many of the older pre-Bruin cases that were upholding all of these civilian disarmament legislation, that is literally the analysis that would be cut and pasted from one of those opinions. And so ultimately, the court came to this conclusion. Having considered how HB 6614 burdens, or more accurately does not burden, the right of armed self-defense, we next consider, for comparison purposes, the burdens imposed by the regulation of other arms throughout our history, as Bruin requires. Yeah, Bruin actually requires the court to do a lot more than this, but hey, they're going to finally get around to doing one thing that they believe Bruin requires them to do. But what they then come up with is the usual suspects. Well, there's been, regulations on Bowie knives. And what about the NFA, which was passed in 1934, but let's not get that in the way, but short barrel shotguns and all of those things. And so ultimately they say there is a rich tradition of regulating abnormally dangerous firearms, unusually dangerous firearms, firearms which are more suitable for military use. They never find them to be dangerous and unusual because they are not unusual, but they find them to be all these other made-up terms, not suitable for self-defense, and all of these other things that have just been created out of legal thin air to justify the ban of large capacity magazines in the state of Rhode Island. And if you really want to understand the level of knowledge, or lack thereof, that the court is operating as it relates to these types of firearms that would use these types of magazines, this is a paragraph from this actual ruling. Additionally, LCMs minimize one of the few meaningful differences that do exist between M16s and semi-automatic weapons: rate of fire. M16s have a higher fire capacity than AR-15s, but LCMs can greatly reduce the need to reload, allowing shooters to fire many rounds in a shorter amount of time. Thus, LCMs enable semi-automatic weapons to function even more like their prescribable automatic counterparts. Both M16s and semi-automatic firearms equipped with LCMs can rapidly hit very many human targets. And while empirically this is not a useful feature for self-defense, it is presumably conducive to combat in war zones. And if you're not convinced yet that the First Circuit has decided to engage in a balancing test of which the Supreme Court threw out on its ass 2 years ago, consider this paragraph. In sum, the burden on self-defense imposed by HB 6614 is no greater than the burdens of long-standing permissible arms regulations, and its justification compares favorably with the justification for prior bans on other arms found to pose growing threats to public safety. Applying Bruin's metrics, our analogical reasoning very likely places LCMs well within the realm of devices that have historically been prohibited once their danger became manifest. Now, of course, I bring this to your attention because this issue is being litigated in several other states, and inevitably, once we see a terrible reasoned ruling like this, you will start seeing it pop up in other jurisdictions. The case, once again, is Ocean State Tactical versus State of Rhode Island. We'll link it up down below so that you guys can geek out on it for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is down there in the description box. And then let's everyone remember, the part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.